Welcome to PitchMark. It is IP week at SG here in sunny Singapore, and we are going to be talking about IP in our show today as well. As you know, on occasion, we review IP clauses that companies put into their tender documents, where you as an innovator, as somebody who might respond to the proposal, is in fact then going to be held to certain IP clauses in that document. What is going to happen to your IP? What is going to happen to the ideas that you submit as part of your tender proposal? That's what we're going to chew through today with another example with our very own legal advisor in Bangkok, Frank Rittman. Frank, good to talk to you.
Good afternoon, Mark. Welcome. Greetings.
Nice to have you with us. And today, rather, we're going to be focusing on a particular IP clause that was sent in. This one's stretching across two documents, and we're going to flash them up on the screen as we go through them. Here are the clauses. In this case, a government body shall have ownership of all data and copyright of the deliverables derived from this project in this tender. It shall become the property of the authority. It goes on to say, the authority reserves the right to adapt or reuse the workshop materials for other platforms not stated within these specifications. But to get to the IP clause, you actually need to turn to a different document in the tender. So you're always well advised to read the full tender specs. Here it is. All documents submitted by the potential supplier in response to this invitation to quote shall be born, or rather shall become, the property of the authority. However, intellectual property in the information contained in the offer shall remain vested in the potential supplier. This clause is without prejudice to any provision of the contrary, contract between supplier and the authority. Anyway, you can see it there on screen for yourself. Frank, firstly, what do you make of this IP clause?
Well, Mark, at first glance, there appears from an initial straight reading to be a contradiction. One section seems to provide for the IP in certain materials to remain vested in the supplier, while another section of the contract seems to provide for IP, maybe in that same material, to be transferred over to the authority. But I guess I start by asking myself whether we're talking about the same things. Now, if you dig down, paragraph 15.1, which comes in section A, so I'm going to presume that comes before paragraphs 2.5 and 6, which are in section C. Sorry to be pedantic. But you notice paragraph 15.1 uses the capitalized term offer. And it's not clear from the excerpts that I've seen anyway how that term has been defined. Whereas paragraph 2.5 doesn't use any capitalized words in it, so there are no defined terms. But it clearly states that it clearly states an intention about copyrights for the deliverables delivered from the project. So I wonder again, are we talking about two separate and different outputs altogether? Now, without the benefit of further definition, the offer, to my mind, would seem to mean the initial material that's submitted by the potential supplier, in this case, our innovator in PitchMark speak, in response to the request for the tender. So in other words, it's kind of like the audition material that is submitted in the hopes of winning the contract. Whereas my best guess is that deliverables, on the other hand, likely refer to the final material that is delivered, if you will, submitted to by the supplier following the authority's positive response to that supplier's tender bid. And I notice in the provision they reserve the right to request 5 revisions. So you put in, here's what I'm going to do. You go through a process, you refine it, you revise it, and then you say, here's what I've done. It seems to be that what they're saying is that audition process, the submission, we're not taking copyright or IP in anything. We just own the pieces of paper that you submit or the slides that you send in, whatever. But as far as the actual deliverable for what we're paying you for, it seems that their expectation is that they would acquire and retain and own all intellectual property in that.
So it seems. So let's take it in that step that you've just mentioned. There's the beauty parade, I guess, when you're doing your pitch, you're looking to win this contract, and then there is the actual delivery in the assumption that you have won it. In the pitch part, how fair is it for the recipient to then own your pitch?
Well, I think all they're saying in 15.1 is they want the right to own your documents, your pieces of paper. They don't want to be responsible for, gee, it was the only copy I had and it was my handwritten thing and you lost it and boy, am I harmed. That's quite different than the intellectual property that's, the ideas that are expressed in that piece of paper or on that slide deck. So I think that's their intention. And the way I read it, I don't think they're seeking to acquire anything in the beauty parade audition, for your terminology. When you think about it, why would they want to acquire ownership in a bid that they haven't moved on anyway? Doesn't make any sense.
That's the theory. But again, as innovators, as members of PitchMark, we would want to be sure that that is not the claim. And what I'm hearing from you is that the documents become the property, but not what is written or the IP over the pitch.
Correct. That's precisely the distinction.
You know, the reason why we approach this with such a cautious and skeptical eye is because in past years, there have been cases where we've seen the person putting out the RFP saying anything that you put into the pitch is now automatically mine. I'm sure you've come across those sort of.
Yeah, of course. Well. There's all sorts of examples of overreaching attempts. And the devil is always in the detail. So you want to be looking as an innovator at things like whether the terms in the agreement are capitalized, because that usually means they're defined elsewhere in the agreement, which usually means they have a particular precise meaning for that purpose. Whereas lowercase letters are typically subject to ordinary meaning in the context of reasonability.
Very good. I do remember a contract, albeit many, many years ago, where the document actually said, when you come to our beauty parade, you will do your pitch. And if we like your pitch and we accept it, great. If we don't like your pitch, you hereby agree not to pitch the documents to anybody else. And obviously, because it was a fairly competitive industry, in essence, that meant that, well, you were now hamstrung, right? If you were now taking part in the beauty parade and you were one of those rejected, well, the competitors were not then able to get their hands on the idea. At least that's the theory. Have you come across those as well?
Well, that sounds like a kill fear, the concept of buying a story with no intention of ever using it, just so that your competitors can't get to it. It happens in, tabloid journalism all the time.
Right.
Doesn't seem reasonable, doesn't seem fair. And I can't imagine why anybody would knowingly go along with that and accept that.
Yes. Well, if it's a very large company, you can be forgiven for saying, well, maybe I'll win it, maybe I won't. But actually, it also then impacts the quality of the pitch, right? Because if you know that there is a chance that the person you're pitching to then lays claim to your ideas, you're probably not going to be too detailed in your ideas, or you're not going to give your best ideas.
That would certainly be good advice. And that presumes, of course, that you've read the agreement in the first place and you're aware of everything that we're discussing.
Absolutely.
Also, other people don't, and that's the sad part. Then you're given 15 pages of stuff and you're saying, figure out what happened. I don't know.
Yeah. Good. Well, that's why we're here to plow through these.
Sure.
And at least, at the very least, in that first paragraph that we've covered, the intellectual property shall remain vested in the potential supplier. Yeah.
Yeah. So again, to me, that sounds like a provisional. Nothing's happened yet. Show me yours. I swear it will remain yours. I just want to look-see at it. I might take up on it, and if I do, see elsewhere in the agreement. But that's where it clearly seems to imply that they're seeking to acquire ownership of whatever you're delivering. And that's where, you've got to ask yourself, is that your intention?
Yes, and that brings us to the second set of paragraphs. These ones much shorter. The authority shall have ownership of all data and copyrights of the deliverables derived from this project, which shall become the property of the authority. And the following one, the authority reserves the right to adapt or reuse the workshop materials for other platforms not stated within these specifications. Is that as benign as the first one we talked about?
Well, it's to me, it's a little bit clearer. Again, you notice they don't, in that provision, they don't capitalize the term deliverables, but elsewhere in the agreement, they've used the term mandatory deliverables as a capitalized term. So, again, I would imagine that part of the process would be you as the supplier are delivering something, some output, some content, some thoughts that you've expressed. Clearly, what they're saying is we want the intellectual property in that, what you've done for us. Given that, which I think is clearly pretty straightforward what their intention is, Paragraph 2.6, you don't need it at all, because if I own it, I don't need your permission or to even tell you what I'm going to do with it. I can do anything I want with it without your consent.
Mm.
So I don't know. Again, it's a little bit odd. Why would you put 2.6 in there if 2.5 is so clearly your intention to acquire ownership? 2.6 becomes irrelevant.
Well, I guess it doubles down on the idea that you are handing over your IP, and to some extent, actually, you could argue that that is valid. If you've now been appointed as the supplier, and you have now purpose created something, knowing you're going to get paid for it, then okay, we could argue, well, that's fair enough, isn't it? I mean, the customer is paying for it. Of course, they would then want to own whatever it is you've created for them.
I would think going in that's reasonable. And again, parties have to be clever. What are you going to deliver? The other side's going to want to make sure that what you deliver is satisfactory to them. You might want to deliver as bare minimum as you can. I remember, Mark, 15 years ago when slide presentations were all about text heavy stuff, and whoever had more words on their slide was more important and smarter. And I remember going to one once given by Google, and the lady on stage just had her first slide was just a simple drawing of a biplane airplane going through a cloud. And then she just talked around that. And I came to realize how brilliant of a concept that was. Because if somebody took that slide, so what? Meanwhile, though, all the brilliance is when everything that was being said and it wasn't written down and it wasn't distributed out to anybody. So if you were there, you heard it. You weren't allowed to record it. But if you took the slide, okay, you got a nice slide of an airplane going through a cloud.
Yes. Well, to some extent,
again, that's how you might approach it, is just dumb yourself down, if you will. Will the authority accept that and let you deliver that? Who knows?
Well, arguably, there's still too much text on slides even today, not just 15 years ago. But but anyway, I think your point is well made. If you never hand it over, then it doesn't fall into the ownership, the copyright claim of in this case the buyer. But once again, doesn't the buyer then do themselves a disservice? Wouldn't they get a higher quality pitch with more detail if they were to say, well, we're okay for you to retain copyright over it?
Again, what's the intention of the parties? I don't think anybody goes into this with bad intentions, that the suppliers want to rip off the party that's paying them by under delivering. So I think both parties, and you start out by thinking that everybody's on the up and up and wanting to deal in good faith with each other. As things go along, it becomes evident whether they do or don't.
Yes. Okay. So in general, I think we've established that if you are providing something for payment for the supplier, for the customer in this case, then yeah, they should have copyright. I guess in the wedding photography space, this has also been a bone of some contention, hasn't it? Does the photographer own the negatives, or do the bride and groom in the photographs own the negatives?
Yeah, that was exactly the subject of a public review down in Singapore a couple of years ago. That very example was used. And
Yes.
it's traditionally been the case that the photographer owns the copyright in the photographs that he or she takes.
Yeah, and unless you arrange with them in advance that you probably pay extra for you to then take on that copyright. But what do we make of this final line then? They reserve the right to adapt or reuse the materials for other platforms.
Well, again, if you own a copyright, you have the right to adapt and reuse it anyway. So I really don't know what they're adding to themselves, what additional they're getting by adding that in that they don't already have. It may raise the question, well, why would you put that in there then if you don't think that you own the intellectual property? So maybe that's the basis of a query. But again, as I read it, a straightforward reading, they're expecting to take ownership of all the intellectual property. And if they own it, they can do anything they want with it. They don't need your consent to reuse it or adapt it for some other purpose.
Yes. Well, so it might leap out at you initially as being a bit of overreach, but once again, if you have received payment for this IP, then why shouldn't you let the customer then repurpose it? After all, you've handed it over. But let's say this was worded slightly different, as many of our innovators watching might experience, where they're, in essence, the customer is saying, whatever you provide us, we can repurpose. Even if it is content from the beauty parade, from the initial pitch document, then you'd probably have a slightly different reading of this.
Yeah, or let's just say it's very clear for the sake of this discussion that we are talking about the same thing, the deliverables. And one provision appears to say that you retain IP in the deliverables, and the other provision seems to say that you transfer ownership in the IP to the over the authority. So let's talk for a second about the assumption that we are talking about, in fact, the same things rather than an apple and orange. Mark, there's a general provision in law that when you've got a written agreement and there's ambiguities in that agreement, they're interpreted to the detriment of the party who's responsible for having drafted the agreement in the first place. So you, as the receiver of this document, again, if it's somehow subject to doubt, what the court would typically do if it came down to it would say, well, we'll give him the benefit of the doubt because you were responsible for creating that agreement in the first place and you didn't express your intent clearly enough.
I see. So
Now,
as the
that's
innovator,
not automatic, though. It's not like judges take it upon themselves to do that. So, that's a general provision. Um, as a more practical matter, though, let's assume for the minute that you, as the innovator, do not intend for the IP and your deliverable to be transferred over. That's not your understanding. For whatever price, maybe they're not paying you enough, or it just was never your intention. It's not what you want. As a practical matter, in some manner, you communicate that consistency that you found across to the other side. You let them know about it. You ask them to amend it. They're the ones that prepared the agreement. So you point out in this instance what the two provisions are. You identify what the inconsistencies are. If it was me, I'd strike out language in paragraph 2.5, or I'd amend that accordingly, so that it's consistent with everything and everything lines up that I retain the ownership. And I deal with 2.6, whether if I thought that was reasonable or not enough. What they're seeking, in a sense, is the right to reuse what they paid for. And again, if they own the ownership, they don't need to ask permission. If they didn't if they didn't own the ownership, it's reasonable for them to accept to be able to do that. But so you communicate that inconsistency across to the other side. You ask them to reflect the agreement. Let's say you do that and they don't, and you want to get on with your life. Amend it yourself. Cross out the provision. Write some handwriting across it. Initial it in the margin. Sign it. Send it across along with a cover note explaining, hey, I've communicated with you before. I've noted an inconsistency in this agreement. I've pointed it out to you. I've asked you to amend it. You didn't. I've therefore amended it myself to reflect my understanding of it. It's signed. Look forward to hearing back from you. That's another thing you could do. See how they respond to that. Another very practical matter that you could do in any instance is put a simple copyright notice in anything that you're delivering. If it's some text materials, incorporate as a footer a copyright notice asserting your ownership of that material. If it's a slide deck, do the same thing. Anything you can to put your position across effectively so that if you do have to go into court, you can say to his or her honor, I tried to reasonably put my position across and they just steamrolled me.
Mm-hmm. Well, in the first instance, how successful is that likely to be, that you handwrite your corrections, especially in a tender document? If there was actually a change in the document, then that would need to be communicated to all the bidders, wouldn't it?
Yeah, well, good point. I mean, as you as a supplier, you're probably just concerned with yourself rather than all the other vendors that are out there and whether the world's a fair place or not. But if they sign it, if you were to amend it and they signed it, yeah, why not? Again, if it were to come into court and you have an agreement where you've handwritten some amendments, you've initialed it in the margins, you've signed it, you've sent across an accompanying note, they've signed it and sent it back to you. Wow, I think the judge really would be inclined to side with the supplier.
Well, let's. Well, I would say that's probably not likely. If you're a small time supplier,
maybe the authority isn't going to sign the agreement. You send back some handwritten changes, they freak out. We're not going to do it. Go away, and that's the end of the discussion. But then you're left with saying to yourself, okay, it was never my intention to transfer the IP over to them anyway.
Cool. Frank, it's been very valuable to get your take. So and it would appear that in this case, everything's above board as long as you actually read these clauses. And I guess, when I think of some of the pitch documents that I've come across over the years, it's surprising how few people actually brand their own slides well. It's starting with their own logo in the corner of the slide, right through to that copyright notice that you mentioned. That seems so basic, and yet so few people seem to do it.
Yeah, I mean, when you go looking at Getty Images and seeing their photographs, they've got indelible watermarks going across each and every one. It's darn near impossible to get rid of that or take it or use it. So yeah, that's an effective self-help method that could be utilized.
Groovy. Thank you very much, Frank, for your insights and expertise today.
Always a pleasure, Mark. Thanks for asking me.
And if you also have an IP clause in a contract that you've come across that you'd like Frank to review, send it in to us, service@pitchmark.net. And meantime, happy IOP week at SG. I'm Mark Laudy here at PitchMark.